Adjournment request, if any, from item number 1 to 4. From item number 5 to 14, adjournment request.
Item numbers?
14 to 18.
Adjournment slip has been sent. All.
June,
Sometimes in
Sec-
June.
2nd June. From item number 19 to 29.
21, right? That we can't say. Either you argue today or rely on our calendar. Be satisfied with our calendar. June, again June.
4th June.
19 and 20, what is the,
Oh,
you're appearing for whom? ONGC.
I have taken the consent from the handle frame, this may not be taken up to the any day. Possibly.
As prayed for on behalf of the respondent slash ONGC 1922 Limited and another, after having obtained the consent of the counsel for the appellant. Yeah, what did I say? Let these two appeals be listed. Sometimes in May.
Yeah.
Yes.
19th May.
You have circulated the adjournment slip. All right. 23 also is with 21 to 23. All right.
9th June.
Item number?
29.
What is 29? This IMFL license.
So they have taken a decision that will not go for the tender.
But I don't think any list is left to be decided here. If you're aware of the facts, I don't know. You're not ready. What do you want? What do you want? आपको आगे bend करने की जरूरत नहीं है. You just have to use your lung power. If you're not, if the microphone is not functional, I think you can speak a bit loudly. Yes. Engaged counsel is out of station. And who is the counsel who has been engaged in this matter? Mr.
H. Bravo.
Here. For the difficulties expressed on behalf of the advocate who has been engaged to argue the present plea, therefore adjournment has been made. Let this matter come up as a question and the appropriate hearing on. When do you want it?
After Bihu vacation.
On sometimes in 3rd week of May. Give a date.
Third
All right.
21st May. Any other request?
My lord, I humbly beg to renew my prayer for listing of the IA I made yesterday. I have taken the consent of the other son.
All right.
Is the
All right. Yes.
Friday,
So this comes on Monday, Tuesday.
Tuesday,
Deeply.
31st.
Consent limits.
Daily list for orders, item 1 to 3.
Yeah, please, Lord. Huh? Oh, I am more used to this.
Yes.
Lord, before I begin, I wish to thank your lordship for holding sittings in this courtroom. And I remember, I should remember Chief Justice Ajit Singh, because he restored the courtroom. Otherwise, it was reduced to cubicles. And I'm very happy to come back and address
No,
your
no,
lordship.
we are also very happy to sit here. Reminds us of the
It's
old
a beautiful
old
courtroom.
traditions.
A lot of,
And my brother keeps on informing me about the traditions of this court, which otherwise I would not have known.
no, he was here also.
Yes, so what is the?
So the pleadings are complete, Lordship. It is a contempt case filed by the Advocate General, Lordship, regarding some remarks made by some counsels. So the pleadings, the counter has been filed. So may I pray that Lordship may take up this matter maybe for hearing in due course of time?
We have no objection.
The pleadings, these matters are complete. Let
Due course
all
of
these
the
matters
episode.
be listed for hearing. We fix it sometimes on a Friday, on a Thursday in June.
Lordship.
That,
June.
June.
Deeply
Right.
obliged, Lordship.
Now, it would be absolutely, to our liking, if it is not made adversarial and some via media is thought of. Let's see if we can do it. If not, we will decide it. on
There
that.
is nothing from my side because there's some very derogatory remarks were made against the institution and the honorable judges.
All right. If it is not condonable, we'll see.
Yes, Lord. The remarks were very derogatory in nature. And that should not be a precedent for future generation also.
we'll
We
see-
have to have
we'll-
respect to
we'll have
this
to see
institution
that.
and we have to have respect to the honorable judges also. Nothing personal here.
We'll
We
see
have
that.
to protect the institution. Lordship has the duty. Identically, we also have the duty as officer of the court.
Mr. Advocate General, Mr. Goswami, times have changed. And, well, let me not speak out the mind of the court. I will see. But then times have changed and so would be the requirement for us to change as well. Let's see if you have said something which is really contumacious, you can always plead for, being condoned. All right, we'll see. We'll see. This is, why I was suggesting this, why I'm toying with this idea. It's only to restore the harmony which appears to have been disturbed for a while between advocates inter se and the bench. That's the only perspective with which I am saying this.
No,
But then
quite.
it depends whether it is so bad that it cannot be condoned, whether the majesty of law would stand defeated if it is allowed to pass off, so on and so forth. We'll consider, but we are not asking you to concede. We are not asking him to concede. No. Think of it and consider what can be done to restore the harmony which once existed
This is,
for
I think,
betterment of the institution.
the lordship is right, because this court has.
But we are not forcing or thirsting anything on both.
No, I quite see that.
All right. So think of it.
No,
I've given you some, that's called tabulum, some food for thought. Consider it. I'm not asking
no,
you to
that is
go
always
my
there.
way,
That is,
but consider
that
it.
is
I have
welcome.
seen this kind of situation in a more difficult jurisdiction, which happens daily. Let's see if
But
it can
this-
be sorted out and we will also reconsider, recalibrate.
There is nothing to be sorted out between us. It's between the advocates concerned and the bench. It has nothing to do with.
And
the
that-
advocate
that
general.
Contempt is always
That
between
way,
That's
contempt,
where, that is why I am not a barrier there.
no.
I am not a hurdle.
You need not be saying that because the idea is that when it is contempt, it is the court and the contemptor.
But are the advocates who have made such comments, are they really penitent?
Below that we'll see.
From the affidavit, it is not apparent.
That we'll see.
Then it has to be.
It is not apparent, Lordship.
Very good.
It should not be an instance for future people, future
No,
advocates.
it-
Otherwise,
it-
tomorrow I can also speak something against the bar if the order is not in my favor. In a different way, not critical analysis of a judgment.
You're absolutely right. Many a times, I have adopted this.
Personal imputation should not be given against any honorable judge.
That's without question. I mean, that.
This is precisely, this has happened here.
My lord, when that is done by a member of the bar, you cannot conclude that it is without basis.
It is without?
Without basis.
No, Mr. Goswami, that perhaps is a defense that you're taking. Then we will hear on merits. See,
Yes,
there
we
could
will.
be-
I am
But
not.
Mr. Goswami, we are not now adverting to the facts of this case. We
Correct.
are only telling you
Yes.
that if you take this stand, it will be a hardliner's stand.
No,
You- you
what
say
what
can
I
under-
hear
we
from the advocate
Just a
general,
minute, Mr.
I
Goswami.
am only
we-
responding
we
in
can
that spirit.
understand some outburst of the bar. But if it is targeted, if it is directed, then it has to have the basis. And then it
Yes,
has to be
that-
within the
that's
parameters of
that's the
civility.
point. That's the point.
It has to be within
If
the
if there
parameters of
is
civility.
without basis, that's one thing. If it is on certain facts,
No, it would be.
that's a matter which
That-
your lordship
That
will have to
holds
decide.
true for the bench also. Suppose I make a statement
Yes.
imputing something against Mr. Goswami. I think I have made myself liable for contempt.
True.
So likewise, there has to be some filter. You just can't blurt out whatever you feel. There are many things which we feel as judges. Don't we?
True. Well, I recall one incident in this court.
But Mr. Goswami, I believe that you are taking, you are defending this, that there is a situation. Then.
No, it's not a question of defending.
Necessity of any.
My lord, if I am hearing from the learned advocate general, the things he has said here, I can't concede that.
No. Advocate General has only said that it is between the, look, I'm not taking sides, but I'm only saying that Advocate General has only said that I am nobody here. It is between the proposed contemners and the court.
That's the law.
It's the law.
Oh.
So he has not said anything to
No,
evoke
but
any
he has
strong
gone
reaction
beyond that.
from
He
you.
has gone beyond that, therefore I was responding. Otherwise, my lord, my approach is, it is always,
And it cannot only be from the advocate representing the proposed contemners. It has to be from the persons who are being proposed as contemners. Correct. And then the affidavit also should reflect that.
it depends, my lord, the situation, I don't know. That we will go into, but
Therefore, we have to use.
I recall one incident before I became a lawyer in this court. We were probationers. Therefore, we were not given access to the meeting which took, and it was a very stormy meeting. The Chief Justice Naidu issued a contempt against the whole bar. And there was a very stormy meeting. We don't know what happened because we were about 4 or 5 probationers who were said that this is not your field, you have to go. So we are out of it. But the bar decided that there will be a delegation to go to Delhi and meet the Chief Justice of India. And accordingly, a few lawyers were selected to go and apprise the entire situation to the Honorable Chief Justice of India. That was done. Then what happened, we don't know. Some message came and the learned Chief Justice was pleased enough to drop the issue and recall the contempt.
Therefore, Mr. Goswami, we said we are also aware of many such, impasse or many such situations which occurred different at different places. I remember. of-
Your lordship is right.
that-
It is reported
But
also.
the question is, in fact, I have also issued contempt of my court in Delhi,
I see.
despite my showing, a lot of patience with the bar. There was an
It
occasion when I
happens,
had to
because I don't say that it will not happen that way.
I also
Yes,
have
it
initiated.
does.
But then it is always, one must realize the fault. If you start looking at the fault line, why this all happened, then perhaps you are not meaning good. Don't look for the fault line. Look for your fault.
True.
And therefore, you don't
If
insist
it
on
is-
that,
if it is-
that it was justified. You see, there could be a problem, but there can be no justification for uttering, profanities.
No,
There
it
could be
was
no
not
justice.
profane. What we said was, what these two lawyers have said is not profane. I don't agree with that.
Anyway, let's see.
And in
Let's-
this case, somebody went to Supreme Court and Supreme Court came up very heavily and said that proceed these matters.
Very good, we'll
In-
hear the matter.
The Supreme
There's no
Court's order
problem.
is here. The instance which my learned senior friend
And
was saying, it
one-
was just the reverse in the present case.
No,
Here the Supreme Court says proceed against the other two.
No,
For one, it is stayed. That matter is still pending. The other cases, the Honorable Supreme Court said that proceed against them.
Because there were two.
There's a
contempt-
direction now.
There were two contemners, one has gone, his case is being
We'll
considered
see.
and stayed,
We have
and
just
the others
some-
obviously
if you
would say
don't-
that.
If you don't scale back, then we'll decide. All
And,
right.
and statements were made before media and it is in all public domain. Had it been inside the court, I would have understand.
No, that
The
is,
people's trust on the institution must be restored,
Yes,
Lordship.
Milord,
we can
I wish-
countenance that situation. It has to be.
absolutely, I have no
The majesty
disagreement,
of court.
but let
The-
let the
the-
Advocate General
First,
say
the
that.
executive
I will
judge-
justify now.
No.
If they want to take it as
You-
an adversarial litigation,
Uh,
I will have a full
yes,
case in my
yes.
favor.
You can, there's no problem. But what you said also was not
Otherwise, I would not,
expected.
actually,
Hmm.
I did not want to pursue any further after making it known to the honorable court. But now I think I should fight this.
Very good. If you want to fight, nobody.
Please address the court. Why you are asking me?
No, I am saying.
You, don't say you.
Mr. Advocate General, we will hear. Now, the proposal which had gone from us, now let it remain under cover, we will hear. it.
Yes,
Highly
Really?
applies, Lordship.
All of it. Some Thursday in June, late June.
18 June.
18,
Uh-huh. All right.
highly applies, Lordship.
And we'll keep it, not in the beginning, keep it at 2 p.m.
obliged.
On that day, we will start hearing the matter.
Yes,
Lordship.
deeply.
Number 4.
लेकिन पैसेज दिया We have already heard a lot of news. We don't want any further. Right? Whichever gentleman has not switched it off, please do it. Yes, follow.
Wait, please, your lordship.
Which is the matter?
Item 4, lordship.
And 4, yes.
Lordship, in this case, not yet issued notice only because that private respondent filed an SLP and that is pending before the Honorable High Court, Supreme Court.
We don't
lordship.
write anything. That matter is pending before Supreme Court. Otherwise, it's a
Lordship,
kind of saying that
Lordship.
please decide that so that. we
Lordship,
proceed.
there is a
That
direction
is,
to,
at the request of the learned counsel for the.
lordship,
petition,
after 8/5, the next stage before Supreme Court is 8/5. lordship.
At the, on the asking of the learned advocate for the petitioner, the matter is adjourned to give a date sometimes in late May.
Deeply applies.
20th May, 20. Item 5 to 9 for admission.
But I think the state will have to file their counter. my lord.
Yes, Mr. Botpuzari, that's the labor line.
Yes,
Level
my
line.
lord, my lord, I am praying for some further accommodation, my lord. We are,
There are other set of matters where.
yes, my lord,
All are tied up here.
all are connected, my lord. We will be filing our affidavit, my lord, in item number 6, my lord.
File your affidavit in all. At least say that this affidavit.
At least
file
the same
this-
copy can be shared to others.
देखिए, Mr. Botpuzari लड़न, any counsel we have need. Submits that the counter affidavit in all these cases shall positively be filed by the next day with a copy served on the counsel or petitioners in advance. Stop in case any rejoinder is required to be filed, that also be done on or before that date, on or before the date so fixed, on or before the date. Re-notify on before the date fixed. Re-notify on, we keep it in June.
Yes.
In fact, we had, our affidavit is ready, we did not file it because against the interim, there was no interim order passed, so they went to the Supreme Court. And in the Supreme Court, they have withdrawn the petition,
But
SLP.
we have, if I remember correctly, I have made a statement on law that legislation is not stayed. I have made that.
Yes. Lordship
So
only
therefore,
said
we did
any
not file it, I am
consequences
just saying.
subject to the outcome of. the
Subject to the.
No, absolutely fine, Lordship, but against that, they went to SLP and they withdrew it when on the date of hearing. So I thought that they may not pursue. That's why we stopped the affidavit both being promptly filed. So we'll file it tomorrow itself. Lordship. It is ready with us.
But we'll hear you in June.
No difficulty, Lordship.
8 June.
Deeply obliged.
8 June. Item 10 and 11.
Okay. Yes.
Lordship.
Slip দুখনমান লৈ আনাচোন। Slip দুখনমান লৈ আনাচোন। Any slip.
Yes.
Yes, this, both the PILs are for Anganwadi Center and the PI.
What's the current position?
Current position in the ground, I have inquired Lordship. With regard to Jorhat district, they have issued advertisement and all. They have
It is
taken the
under
name.
process.
Sir, the process, but building, nothing, no.
That they will do. We keep
Sir.
it after the elections. We'll see. We'll keep it after the election.
Election and another,
Because now, no department would. be
yes,
working.
I can understand Lordship because of the process of election. Lordship, in the second PIL Lordship with regard to Hojai district, there is another one additional prayer for electrification of those villages also.
You have taken note of this, Mr. Sharma?
As far as electrification is concerned, my lord, there is a
If it-
standing FADCL, my lord. We cannot,
But you take all these.
I'll inform the council for the
From
FADCL,
the councils, we are keeping it sometimes in mid-May
my lord.
as jointly prayed for. Let these two cases be listed sometimes in last third week, May or last week of May.
Okay.
28 May. Item 12.
We have submitted that written submission.
Lordship, kindly pass on for time being, Lordship.
Let him complete his answer.
Basically, what
It is not officially given. See, showing the good. We will do it. We will answer to send the answer. What is there? Say your decision. Or you cancel the entire process. You must agree to it. If not leaving person, it doesn't. So,
copy এটা ইয়াতো দিছা তো written argument of which paisa to
Structure is this continuous, difficult to administer. Yes.
Look, essentially what I would like,
Before both of you proceed,
ইফালে নালাগে এইটো নাম এইটোৱে নাম
we find from the sequence of events that this kind of seesawing, which appears to us for the present endless,
yes,
this is not serving any purpose.
yes,
So we will explain this, subject to, of course, what you argue.
Milord.
This is just a preliminary observation from the court. And since the advertisement is of 2019,
yes,
either we say that notwithstanding the judgment which has been impugned, decide it on the basis of the marks, or initiate a fresh advertisement process and conclude the process within a period of 3 months. And I would be backed by a Supreme Court decision on this, that it can't remain pending with judgments coming this side and thereafter that side. And the post is manned by an in-charge principal.
yes.
That cannot be done. So if you people agree, we say that let all this be avoided and let a fresh notification be issued. We can do that. It would be a kind of, now this appears to be a kind where the parties have approached the court in such a manner that court is ready with a continuing mandamus. Do this, do that, do this, do that. We don't
Something like that also.
we don't think this is very advisable. So we have given you our thought. Think about it. We will say constructive res judicata, all right. We will, Daryao is very alive in my mind.
Modi also, Milord.
Modi, Daryao to begin with. And
No, Milord, there is one more thing, Milord.
now what we do is this. Now,
Yes.
notwithstanding all this, notwithstanding the legal ground on which you are standing, or
Whatever
Mr.
they are
Saikar
standing.
says, but then this means nothing. It has been almost 7 years and the litigation is going on. And what happened after the single judge's order? Did they do anything?
No, Milord, because we approach your lordships.
So we approached, there is no stay.
Yes, no, no.
No stay. They should have done it. And the matter would have been over.
Yes.
Now you take a call.
Only with
Take a
factual.
call on this. Because prima facie we find that this is not the way in which the court should interfere.
Yes. No, no, Milord. Only thing is, one aspect lordship will kindly consider. When the selection, he was selected, then everything was good. So I have, that's why I pleaded approbation and reprobation also, Milord. Now, is it not a case, Milord, when he was appointed, when we filed the writ petition, he said, no, no, this selection is good.
Agree.
Yes.
Only when we approve of the situation which is
No, Milord. Number two, when he approached for the first time, he suppressed the material fact. Kindly see the conduct, Milord.
look at the interference at the stage when no decision had been taken in the first instance. No decision had been taken because there is no guarantee, there is no mandate.
And
that
most
any person-
importantly, Milord,
This question
there is no order in his favor, but he continues to be the principal. There is no order by the authority. This stay order means my order is appointed. His stay order, his appointment does not revive. Kindly see, Milord.
if your contest.
No,
leads
Milord.
you to any
Since your lordship has given a suggestion, I think we have waited for so long. Let the matter be called on Monday, Milord. Let me inform our client also, this is what is being proposed. What do you
This
say?
is what is being proposed because the court is not happy. You can say
The
that.
manner in which, I
The
mean,
manner in which this is continued,
Hmm.
whatever may be the legal ground. So otherwise, we can give our exposition on constructive res judicata or the lack of it.
follow.
But then for both sides, but then ultimately what we will decide is.
In that case, I'll be loser because at least there's an order in my favor today.
Take a call because this we
And
can.
lordship will call the matter on Monday, Milord. At 2 o'clock, I'll have the instruction.
We are going to give you that. But this is what came to us in the first instance when the facts were seen.
No, Milord, all that I was trying to persuade your lord, no, Milord, maybe on Monday I'll have to do that. Look, this doctrine needs to be enforced for the simple reason it is based on a public policy. It should come to an end.
We are saying also in the public policy.
Yes,
We can't go on interfering every time.
right.
We can't.
No, No, my lord, initially this was something else. Then when he got appointment, everything is honky dory.
Occasion to speak to the advocates of Supreme Court on a platform where I said that, you know, the strength lies as much in restraint as in intervention. And I mean it. And I think my brother also agrees to it. It's equally important. Now, should the court have intervened in the first instance?
And my lord, on Monday, I'll have the
All
instruction.
right. Mr. Saikia, you also.
Hey, মই জানো, সেইটো যে ক'ব মই জানো আগতে।
Agree.
Next day I'm thinking about.
Just a minute, Mr. Saikia, if you don't agree, you will have full platform to act.
No, my lord, here some, my lord,
When I'm
actually,
retiring?
my lord, Lordship has
July.
said that I am.
My lord, the whole
so I am-
difficulty is I'm
my lord,
retiring
I
in
am-
July.
No, therefore Monday.
I am, my lord,
Yes, Monday.
serving as an in charge, but it is not, I am pursuant to a, my lord, valid order passed after this election. I have been working. That order of my appointment.
Suppose we accept your statement without a demur.
Lordship.
We accept your statement,
Lordship.
Mr. Saikia, but the sword is hanging on your head, no?
Lordship.
With this litigation, or is it not?
My lord, what is only two documents,
Anyway,
equal-
you
Lordship can
take a-
decide, Lordship can decide, this court also can decide, my lord, only looking at the two documents, my lord. My lord, firstly, the office memorandum by which the marks patterns are given, how much marks you can give, and how much the state has given.
No, you were happy with that mark
Yeah,
when you got the appointment.
Wrongly or rightly, Mr. Saikia,
Lordship.
if we look at the constructive res judicata, the not allowing a party to blow hot and cold.
But that does not
Appropriated
arise at
retrobate.
all.
No, but unless we decide that, we can't get into the pattern of marking, no.
I'll take
Here
it
we
all
have
as your
taken-
lordship has
We have
suggested, my
taken,
lord.
Mr. Saikia, we have taken a third stand. You know what happens in appeals? Your two stand, the stand of the court, and our fourth stand in appeal. And we are very, very justified in saying so. According to us.
Lordship.
You may not approve of it, or Mr. Chaudhary may not approve of it, but
No, my
we
lord.
are, we are absolutely justified in making this statement. Now take a call, come back to us, both of you will start on a clean slate. If it is possible, otherwise we decide it. And even otherwise, we must tell you, because of this seesawing, we would not require your concession. Yes, no offense meant.
No.
Don't take it otherwise. We are only taking a course. We are adopting a course which, according to us, is the correct course. Now we will give both of you a clean slate. And in that case, we will direct that nothing shall weigh with the appointing authorities. 9 years it is continuing. Nobody is there. What is this? And we will express our regret also that this is what happens with intervention when it is not required. We can
Kindly see how the stay orders were passed, my lord. Look,
Take a call. We
Yes,
are ready
Monday,
to give you
Monday.
a clean slate. Both of you.
my lord, actually tomorrow I am not there, otherwise I would have called for tomorrow only.
No, we keep it
On Monday, my lord.
Yeah, Monday. Monday.
Monday.
Look, only little recommendation. On my second, my lord. First, I have some, my lord,
First.
on-
Monday is
with this-
30th.
Monday is 30th.
30th. Monday is 30th. Yes, yes. 1 or 2 days here and there, it doesn't matter. Tell me, Mr. Saiki.
It is on my lord, second of April, my lord.
2nd of?
April, my lord.
No, my lord, 2nd of April, I have difficulty. Let us keep it on 30, my lord. Monday. He is the beneficiary of that order.
There's nothing, my lord, only, my lord, the allegations, my lord, one after another, my lord, have been taken, my lord. My lord, he's saying that I have suppressed.
1st of
all this,
April,
my
how
lord,
both
the
of you are
attention
pissed?
not to be given.
On 1st of April, how both of you are pierced? Tell me.
That's the April Fool Day, my lord.
So, how are you placed on that day?
1 तारीख की हो?
Huh?
31st March.
31st March. 31st March, Mr.
Okay, 31st.
Tuesday.
Do we say something? Background facts?
No, my lord.
I think let me dictate some facts. Then they take a call. Let me give an introduction why we are.
My lord,
saying that. This is a long running battle between the appellant and respondent number 6 for the post of principal at Bamung Dongara Higher Secondary School, Barpeta, Assam. The sequence of events are as hereunder. On 30/5/2019, an advertisement was issued by the competent authority for selection for the post of principal, Bamun Dangara Higher Secondary School. I'll say school, you write that. Bamun Dangara Higher Secondary School in the district of Barpeta. The school selection committee had prepared a panel of candidates where the appellant was placed at serial number 1, whereas respondent number 6 was placed at number 2 in the merit list. The list of persons to be considered was then placed before the state selection board, which in turn referred the list to the government for its approval. It may be noted here that no selection had been made till that time. However, respondent number 6, on being placed second in the merit list, filed a representation before the Director of Secondary Education, Assam, making a request to re-examine the select list and find out and re-examine the second list and re-examine the second list before the list is acted upon by the authorities. The re-examination of the list was done by member secretary, State Selection Board. The State Selection Board after critically examining the preparation of the list, approved of it, which gave way for the appellant to be appointed ultimately. Respondent number 6 thereafter. But before any selection was made, before any final selection was made, referred a writ petition, bracket WPC number 7980 of 2019, challenging mounting the challenge that the re-examination was never done and which list was already prepared was forwarded for selection. At that stage, a bench of this court disposed of that writ petition with a direction to the authorities to complete the process of selection initiated pursuant to the advertisement. Whatever may have been understood by the authorities by understood of the directions referred to above. The prospect of the appellant being appointed, even though marked first in the list, was marred because of a cloud over his B.Ed degree, which at that time was found to be invalid. As such, a decision was taken to appoint respondent number 6 on the post. On 29/7/2021, the respondent number 6 was actually appointed as the regular principal of the school. Next, this appointment was challenged by the appellant later on the strength of the charge against the appellant of his having staked his claim on an invalid B.Ed degree was questioned and the bench of this court in WPC number 3558 of 2021 directed the government to verify whether Barpeta BT College, from where B.Ed degree was obtained by the appellant, was actually recognized by the NCTE prior to 18/8/97, and then decide whether the B.Ed degree of the appellant was valid or invalid. Once it was found that the B.Ed degree of the appellant was valid, on 9/3/2023, the government in the secondary education department decided to appoint the appellant as the principal of the school in place of respondent number 6. The appellant was appointed as a regular principal on 29/4/2023, and respondent number 6 was reverted to his original post of postgraduate teacher of Rehabari High School, Barpeta. This again was challenged by respondent number 6. On various grounds, inter alia. One being the resort to the marking pattern by the authorities. This time, the High Court again This time the High Court, setting aside the appointment of the appellant as principal of the school, remanded the matter to the Secretary, School Education Department, to rehear both the appellant and respondent number 6. On the issue of validity of B.Ed degree of the appellant. The contention of the appellant is that the order of remand on a particular aspect was accepted without a demur by the respondent number 6. Thus, he would be presumed to have given up his challenge to the statement of marks where initially the appellant was given 20 marks, whereas the respondent number 6 was given 18 marks, and later both were awarded 17 marks. Some time elapsed, and it was found that B.Ed degree of the appellant, on a fresh verification of all related records, what did I say? Was valid, the appellant again stood appointed as principal of the school on 18/8/2024. Respondent number 6, thereafter, again challenged the appointment of the appellant, questioning the correctness of the marking pattern and grant of marks to appellant and respondent number 6, both, even when that issue, after being addressed to, was not the plank on which the remand order was made for verification of the validity of the B.Ed degree of the appellant. The impugned judgment dated 31/10/2025 asked in the writ petition preferred by appellant number 6 contains the direction to the Secretary of the Government of Assam, Department of School Education, now to again re-examine the marks given to both the contenders in terms of OM dated 26/12/2018 and come to a definite conclusion within a period of 2 months. In the meantime, according to the averment, the respondent number 6 continued to officiate as principal of the said school. The contention of the appellant, however, is that over a period of time, respondent number 6 was suspended. And there is an in-charge principal governing this school for all this while. Stop. Several arguments were initially advanced by the learned counsel for the parties, justifying their appointment, their respective appointments to the post of the principal. However, we, after going through the present sequence of events, demonstrating seesawing so far as appointment of a principal in a school is concerned, for 7 years, we tentatively came of the view that the entire process has become the entire process has become a source of orders which ultimately becomes futile. And it would only be appropriate if the entire process of appointment of a regular principal of the school is started afresh, giving both the appellant and the respondent a clean slate to clean slate, a clear field to stake their claims and compete with each other. But in that case, a fresh advertisement will have to be taken out with the specific directions for the pattern of marking, so that the entire process is completed. It is really unfortunate that because of this litigation between the parties, intercede two claimants, the school does not have a regular principal for approximately 7 years. So this is not a comfortable situation to be in. On hearing the view of the court, the learned counsel for the parties, namely Mr. K.N. Chaudhary and Mr. T.J. Saikia, learned senior advocates, respectively, seek some time to take instructions in the matter and get back to this court on 31st of March. 31st of March. Put something of March also. We are still in March. We will not see from there. 31st of March at 2 p.m.
Deep privilege. Only one clarification, Madam, what I'm saying, Madam. So far as in charge is concerned, it is recently because of non-submission of an audit report. I have been, my lord, the inspector has taken the in charge. Otherwise, all along I have been.
The learned advocates for the parties contend that in fact their respective appointments on the post have never been specifically cancelled. Therefore,
No, his is cancelled. His is cancelled, my lord.
oh, his and his.
His cancelled, not mine.
Anyway, we will decide about it on facts.
How can you make that statement? Yes, well, I'm submitting. I'm submitting.
आपकी cancel हुई।
नहीं मेरा cancel नहीं हुए sir.
Milord, his appointment
he
was
had challenged-
cancelled and my appointment was stayed.
No, my lord.
It would reduce everybody to
Sorry,
a laughing stock if this happens.
He's-
And then it will be a
No, my lord.
constructive.
I don't want to get into all this.
Constructive res judicata would squarely apply, and otherwise also we should restrain ourselves from doing this. We will end the litigation. Anyway, tell me, yes. Be very sure on facts, because we'll be recording whatever you say.
No, my lord, so far as my lord appointment, I again retired. My appointment is of 29/4, that has not been cancelled, but so far his appointment that has been specifically set aside.
Now, Mr. Saikia, we are finding fault with all these orders.
Lodge,
Of remand.
that is besides. And secondly, my lord, in charge only recently.
Demand and for 16 months, you don't give the orders. 2 months.
Anyway, tell you next. Lodge. And who are you?
He did not file anything, my lord.
That we will decide, no? We have asked them, we have said that unless, if they concede it's all right. If they don't, we pass an order. Therefore, we have said
Actually,
tentative.
A proposal has come from the honorable court, therefore we'd like to advert to our client, that's all.
Your interest is to have a good principle. So if advertising other competitors comes, what is your difficulty?
No, he says that we want that.
Huh.
He wants that. All right, you give your stand, we will say. On that day, we will incorporate your stand. I'm sorry, this is no mediation, this is no panchayati, this is deciding a case, but in this matter, we can't possibly decide who is right, who is wrong. Now that cloud is over.
No, well, we'll have the one, if my client agrees, well, or else we'll not, already given, well, not will pass an order.
Rebutted, we will say what we have to say. Therefore, instead of you telling the views of the court, we have put it down in
In
writing.
the order, yes.
Yes,
Item 13 for hearing.
Item?
Wait, please, Your Lordship.
अब इसको फाइनली कर दो, you do this later on. Books may intercept. Yes.
Matlab, in this case, matlab, the sole respondent died, matlab, we were supposed to file an application for substitution. Matlab, in the meanwhile, this file got missing and we constructed it. Lordship, give me 10 days time to file my application for substitution of the respondent's son, matlab.
This, but they made a statement that they will not claim anything legally or.
If that be so, matlab,
Last week.
Anyway, बहुत सारे चीज चलेगा.
because otherwise the judgment, matlab, gives a,
Lordship, we already filed an additional affidavit regarding the death of the sole respondent, Lordship. And-
That's why
yes,
you
yes,
are
that
the-
is. that-
Yes, yes. And now, Lordship,
Can you provide the name of his heirs, Platinum heirs who need to be substituted? Is the son there? Wife, son?
yes, Lordship.
So provide that.
I'll-
to him.
Yes,
Yes. yes.
Okay, what is your name?
B. Kaushik, matlab.
Mr. Kaushik. Learned counsel for the state of Assam/Palan.
Lordship, what happened in this case, Lordship, if the respondent,
And you represent a dead person.
Lordship,
So,
yes,
so his heir has to be impleted. That's what he's asking for.
Yes,
And we are
Lordship.
allowing his prayer, we are giving him time, he'll file necessary application for substitution.
Substitute.
You will not disagree. Therefore, we have said that out of court, you can tell him who is to be substituted, wife or son. And he shall make a prayer, we shall allow that, and then we'll hear you.
as per my instruction, Lordship,
Unnecessary, if you hold back the court for nothing,
there is no any claim, Lordship,
there is no claim. How
yes.
can you say that?
As per
Madam
my
Counsel,
instruction,
can
Lordship,
You are not representing,
Lordship.
she will be in difficulty.
आप अपने को difficult position में ला रही हैं.
no,
You're the son of the respondent. You
respondent.
say that who are you to say all this?
yes, Lordship,
I received instructions.
I have the instruction, Lordship, but I want to bring out the on record, Lordship.
If you put it in writing, he will
Yeah, that's-
withdraw his appeal.
Yes.
Put it in writing, he withdraws his appeal.
Lordship,
That day also, when he files a substitution petition,
yes, Lordship.
you say, it's very good. If the son or the wife, the surviving heirs, they say that they don't own anything from the government, why should he
Why should they pursue?
file
Yes,
an
yes.
appeal?
But I have just instruction, if,
Please,
if it-
without a written instruction, I'm
Yes, sir,
really
yes,
looking
yes,
after
yes.
your interest.
yes, Lordship,
Your interest, because you should not face the flag
yes, sir.
when they turn their, opinion and they
Yes.
say that, no, we wanted. You take instructions, file a 2 pages affidavit. In the meantime, we give him
I'll-
time for filing substitution.
Yes, Lordship. Yes.
Thank you. Mr. Kaushik, learned counsel for the appellant/state of Assam. File a substitution petition as the sole respondent has died. However, the learned counsel appearing for the respondent admits that she has clear instructions not to pursue this matter. Stop. In any case, we are adjourning the matter. In any case, the matter is being adjourned for the appellant state to file a substitution petition and also an affidavit on behalf of the heir bracket S of the respondent whether they would be interested in pursuing the case. Re-notify after 2 weeks.
I am grateful, Lordship.
Grateful.
April. 20. Item 24 to 26.
Kirala Satra. Yes.
May I please your lordship? These matters, my lord, I am led by learned advocate general, my lord. Today, some difficulty, my lord, we could not effectively prepare it, my lord. So I'm seeking an adjournment for
Then
today.
it goes in,
My lord.
in May.
May, my lord, third week, my lord. Third week or fourth week, my lord.
4th week of May.
May,
So first week of June also is agreeable.
my lord.
What do you say, Mr. Taylor?
My lord, we'll have it in May.
Yes.
We'll have it in May. All right. A prayer for adjournment is made on behalf of the respondent state. It is indeed. We can see from the rubric itself, it's an appeal of 2023. Now, what do we do if the main, if the main party is being led by an advocate who has some difficulty today? Don't we adjourn it? Whose interest do you represent? Satra? No. Then? Depending on Goswami, he is the Satra, but he is made the party as a in-person. They have not made party. Wait up. The category is not to consider. What is the reason behind it? All right. So in the absence of the main stakeholder here, the state of Assam, which has taken the land in the garb of some legislation dealing with religious institutions and an order and a judgment of the Board of Revenue sometimes in the year 2005, which probably was not understood appropriately. That is what they claim, the appellant claims. And there was a statement which, because of bad printing or whatever, it could not be understood. It says that there is no dispute that it was never a Satara land. It was understood that there is no dispute that it was a Satara land. I mean, something like that. Therefore, we had asked for typed verified copy of the judgment of the Board of Revenue of 2005. Now, there is no challenge to that order. No, therefore, we have to see what is there, because the regular refrain of the parties is that even if there was a dispute, it was with respect to 18 acres or 18 bighas of land, but the government took this as a tool for taking away all 105 or 110 bighas. We have to decide it. No, here we have understood your we have understood your anxiety, but can we decide on your lecture? No, we are asking you. We are asking you that if a prayer for adjournment is made in a matter on a ground which we think is genuine, what do? We don't adjourn. Therefore, this objection. All right, sir, you have made your objection. They have heard it. Next time they shall ensure that the matter is heard. Please don't embarrass the advocates who have made a mention. All right. The court is required to hear all parties. Therefore, we have heard you. But granting adjournment is the discretion of this court. We are conscious that it's a matter of 2023. We are ready to hear it. All right.
I'm so obliged.
21st May.
On behalf of the respondent state, on account of some difficulty of the learned advocate general is to address this for stuff. There is a consensus amongst the parties for the matter to be listed, for these matters to be listed on, give a date sometimes in late May.
21st May. Sorry.
If I fall ill, then what happens? Therefore, if that day, for some reason or the other, the bench is not constituted, what happens? So therefore, let us.
Item 27.
Re-notify.
Item 27.
Problem.
May I please,
Yeah.
your lordship, I pray for adjournment today.
You are for the bank.
Yes, I am.
Perversity you'll have to show.
Yes,
We may not be totally agreeable to this kind of an order in a case with an allegation of total fraud. Expiation doesn't mean anything in law. That's right, that's an argument. But then it is not perverse. The order is not perverse.
I have to support.
And he appears to be clueless what the court is saying. We may not have done it, but then once it has been decided and we don't find any great flaw, any big fault line here, because it has been left open to you to initiate a proceeding for lesser punishment or whichever. You can do that.
Yes,
Or you've challenged it. You have every justification to challenge it. We'll see. The reasoning why what is that? The sentence, the punishment is reduced is to our mind not very acceptable. What is that called? The principle of law is necessitatis inducit privilegium, quo ad zura privitum. Now suppose somebody steals a loaf of bread, even if he returns it, he expiates for it, he does some labor in the shop, or he returns that loaf, that does not take away the right of the state to punish him for felony. Correct? But the other law also operates that there is nothing perverse in the judgment.
I have to.
As prayed for on behalf of the appellant / Union Bank of India and 5 others, the matter is adjourned to June.
June. Item 28.
May I please not? Not the issue here is, my lord, regarding, my lord, the respondents here in, my lord.
Just give us a minute.
My lord.
I'll just read the synopsis and then get back to you.
Yeah.
Consent failure?
Hmm.
Why did he raise consent?
Only because I had Zopa instruction.
Mr. Mahanta, I think you will have to respond.
Yes.
They had once consented in the first instance. Now their view is, I don't know what he will argue, but then if it is what we have understood is correct, then you need to respond. He says that this is government land. Now, could the court have decided it on consent? Who was railways to decide that? And then again, now do we say that, well, once you had consented, once the appeal was dismissed, review dismissed, then it's a fresh challenge. But appeal was dismissed, no?
Review was dismissed. Earlier appeal was
Sorry, appeal was, so
Withdrawn.
therefore, this has to be heard, no?
Well, no, kindly see. Firstly, the original,
Shows the proof, because you see, the single judge, we can remand the matter to the single judge. The question is that the unilateral withdrawal of consent, especially with respect to ownership and possession, if it is in dispute, some advocate would have appeared for the railways, would have said, I mean, we can take a strong exception to the stand taken by the railways as a litigant. But then once they said the consent order was passed, if they found that this order was passed on some misconception, in fact, the appeal should have been entertained, even if there was a delay, because it concerns the rights of the parties. Therefore, unless-
kindly see, here is the Malad, what I find is, railway took the land from these petitioners on lease initially for temporary use. And then they use it permanently for making a road there. And the state government says, the authority, revenue authority, that they have been in possession since 1771. They are the owners. And Lordship, my Lord Chaudhary will appreciate.
Just all are not owners. There are some Exonia Patta.
Exonia Patta is there, 1 year. Annual land, annual Patta land.
But the revenue affidavit clearly says they are encroachers. The affidavit filed.
No, no, my Lord, they are nobody to challenge it. Kindly, my Lord, Lordship has right to say. Railway, can the railway challenge my right?
Have they got the patta cancelled, the railways? Then we dismiss the section.
My lord, we
Kindly see.
One is Exonia, that we have given already to them individually, and those government land is given to the government.
Where is the proof that those lands are not owned by these respondents?
the state government in the affidavit, my lord, clearly said.
It is your affidavit. Why did you concede then?
No, my lord, we have not conceded.
No, where is the consent order? You have not conceded.
Yes, this is the consent order. They have admitted clearly.
No, my lord, we filed a.
Before the two
That is
courts.
the reason why appeal in the first instance was
My
withdrawn.
lord,
You
when
filed.
we filed review, we have clearly stated that. the
We
consent-
don't want your affidavit statement.
My lord.
Shows the proof.
In the review, my lord, liberty was given.
Where
to
is
us
the proof?
To file appeal.
So we are listening to the
My-
appeal. Now tell us, how do you say that the land belongs to you,
The land belongs to.
to government? And they are
Yes,
just
yes,
encroachers,
yes.
the consent order would not operate so
No.
far as they are concerned.
My lord. My lord, I have given a list of documents, my lord.
You give show us documents which are part of record.
Record.
Yes, they are part of the record, the affidavit filed. by-
Kindly see the deputy
Affidavit
commissioner.
filed by the state government. It is-
What is that?
That was again,
Document number 1, my lord, which I have given, my lord. This is the affidavit filed by the deputy commissioner Damaji. Paragraph number 3, first document, my lord. It is marked 1.
Affidavit filed by
This is part of the report.
Piyush Bhaskar Reddy.
My lord, my lord, my lord. Page 3, paragraph 3, that the land measuring 219 bighas, 4 kathas, 16 lichas of government land involved in the instant writ petition has not been acquired, and so any award has not been passed. to
That
that
is their
effect.
case. You say that this was initially used for
Service road, my lord. For the
Service road.
construction of the service road, my lord, the
Who is this?
deputy commissioner, my lord.
We
Deputy,
need to call him. Is this the affidavit that we accept in an appeal? That
no.
the land measuring.
not in appeal, my lord, it was filed in the lower proceedings for the single
That the
judge.
land measuring so and so involved in the instant writ petition has not been acquired, so any award has not been passed to that effect.
The
Correct.
petitioners-
You had not acquired any land. In fact, you had taken it on permanent lease. Correct?
Yes, yes, ma'am.
And you paid them the lease
These
charge.
charges, yes, ma'am, yes, ma'am.
Yes, yes.
And now this set of petitioners, they are claiming land compensation for permanent acquisition. Whereas there was no permanent acquisition. The rates, my lord, which the deputy commissioner has given the railways to pay,
That is something else.
that is what our grievance is.
That's
We are ready,
correct.
my lord.
Don't keep on repeating. You have created this mess and we can record it. That your land was acquired is one aspect of the matter. That their land was acquired is one aspect, acquired or not acquired. You say that the respondents were never declared as owners and pattedars, and they have the document to say that they were the pattedars. How do you dispute it?
To that, my lord, if we have,
And you will be relying on this affidavit.
my lord, may I
If this
submit?
is the case, we record and we dismiss the appeal without hearing.
My lord,
What is this you're doing?
my lord, if they are pattadars, my lord, we will give them the lease charges. My lord, if they establish, we have, after the single judge's order, my lord, we have repeatedly asked the revenue authorities and the owners also to bring their land ownership documents. If they
We
provide,
sitting here in appeal, believe your statement with this kind of a perfunctory affidavit.
this is not our affidavit, my lord, this is affidavit by the state government. This is not our affidavit.
And where is your affidavit? Where is your affidavit where you said?
Yes.
You're making wrong statements, Mr.
Page one,
Gupta,
page
Mr.
one.
Das. Yeah, no,
This is
no.
not a, I'm not making wrong statement, Lord. I'm highly, Lord, I may respectfully submit. I do not make wrong statement, my lord. And whatever I say, my lord, in the
This
court,
certificate has to come from us, not from you.
no, my lord, I may submit, my lord, because it has been repeatedly coming from my lord.
Yes,
That's why, Lord, I have to submit that I do not make wrong statement, my lord. In my 18 years of
but where
practice,
is,
I have never made wrong statement.
that you may pat your own back,
My lord.
but we are not finding it exactly true. Where is your statement in the appeal that this land was never acquired by us, even
My-
on lease?
Yes, yes.
Where
Lord.
have
Just then, my affidavit is at page 151, filed before the learned single
No, no,
judge.
where, in this appeal, where have?
Yes, my lord, 151, page 151.
Same problem with me also.
Paragraph 5, my lord. Page 151, paragraph 152, my lord. Paragraph 5, if I may read.
Therefore, you see, our outburst is because of this. You don't understand and still you insist. What you're
My lord,
showing,
Yes.
what you're showing is trying to understand.
No,
There is no anger against the advocate.
no,
We get irritated if we are not understood.
no, I'm ready to cooperate.
So therefore, don't take it personally
No, no.
that I am saying that you're making a wrong statement. When we say that, it is your client and not you, not
No, no.
Mr.
No, no.
Gupta.
No.
But these, these responses further concretize our feeling that you're not understanding and therefore a wrong.
We have contested in review, my lord, that is why we filed review.
You're not understanding what we are trying to tell
Came
you.
to a-
सुनिएगा आप तब
No, no.
तक।
Sunil, wait for something. What my lord is saying, just
When
understand, then
we
you
say
respond.
that you are making a wrong statement, this is a reference to the deponent.
No, no.
Number one. Number two, make it very clear. These responses further strengthens our view that you are not understanding. So please restrain from making that comment.
No.
That repeatedly this is being said. We will keep on repeating this unless you satisfy us. And don't think that the court will go on the back foot when you make that statement that you're very hurt.
Obviously not.
If you're hurt, you're hurt. You can walk out of this case.
No.
Don't try this with a judge who has seen all weathers.
Just trying, my lord.
So therefore, don't take offense of what we say.
No.
This is against the deponent and not against the advocate. If you think that by saying this, I will hold back my comment, you're sorry. I mean, I'm sorry.
That
You're
was
wrongly
filed
adjusted.
by the state, not by.
That's all right.
That is
So you
what
can say that.
that was-
Don't take it very personally. We stand by what we say. I have asked you for the statement in appeal. You're showing me the affidavit.
No,
If this is your understanding, we are again repeating.
My lord, pleadings, I am coming.
Lordship is asking your statement and pleading in this regard in your memo of appeal.
My lord.
ये है
Paragraph-
ये
paragraph
pleading है,
three-
an
paragraph-
actual pleading है. तो आप अभी तो you just took offense that why the court is saying.
No, I'm paragraph 3 of my petition. Page
समझा
30,
आप मैं
page
जो
30.
बोलता हूँ वो कुछ सोच के बोलता हूँ.
Page 31, my lord.
Is 31.
Paragraph 3.
पढ़िए.
That the railway authorities before the learned single judge filed affidavit in opposition stating that for construction of service road, the following area of land was took on lease, executing deed of agreement between railway and Amadhir Pegu and 53 others landowners with effect from 7/3/23 to 6/3/13 for 10 years on payment of rupees 22,52,896. Only white check number dated 30/3/2002 and payment of lease amount disbursed by ADC Revenue Dhamaji amongst 53 landowners as per the letter dated 18/1/2005 in respect of Patta land 63 bighas, 0 kathas, 12 lichas. The land measuring 63 bighas, 0 kathas, 12 lichas belong to the legitimate patta holders, and these lease agreement for 10 years were executed with these patta holders, which was witnessed by the then circle officer Sisir Borgaon. The further extension of lease period was made for land measuring 63 bighas, 5 lichas at charge of 30 lakhs.
Just a minute. ये कह रहे
हाँ,
हैं तो ठीक है.
Further
ये
extension.
कहता है कि वो जब इसकी कंसेंट ऑर्डर गलत था, इसको पेमेंट चाहिए, इसको कॉम्पनसेशन नहीं चाहिए. कॉम्पनसेशन we will say that it is compensation. That's what we will ask for, Mr. Moon. Compensation for the use of the land. But इनके कहाँ statement आप देखिएगा कि where have they said that this belongs to the government and therefore we have taken it, we will not even pay the compensation. Look at it. Yes, continue.
The lease agreement was extended till the year 2018. And in February 2018, the leased land was returned to the landowners and information was given to the deputy commissioner. My lord, this is, we have stated, my lord, that in respect of the government land, 201 bighas, 12 lichas, it is stated that the said land was a government land and hence the petitioners residing on the government land are not entitled to any
Now, Mr.
compensation.
Gupta, should you not have argued before the learned single judge that even if they are not squatters or encroachers of the government land,
My lord,
if it is found that their lands was used under lease by the railways, they don't require to be compensated. Compensation is not for the acquisition. For the lease period, they would require the rental of the land.
my,
Correct?
my lord.
You are not paying them on the plea that they are squatters. They don't.
No.
How do you prove that? इतना घुमाने से अच्छा है, you have to filter करिए अपने arguments को. That is what we say.
Lordship.
So where is your statement? How do you support it that it was the lease which you have taken? This land is not out of that lease. It's a government land. You have taken lease not from the respondents,
No.
from the government. And
No.
therefore the government in its wisdom would not like to charge you for that. ये कहाँ है? Where is that statement?
It is there.
How do you prove?
My lord, this is the first one, my lord, that in respect
ये
of
तो कुछ नहीं है.
government, my lord, it comes further, my lord, that the railway department has taken a specific time.
Just a minute, Gupta. You have taken a stand in before the learned single judge that annual patta landowners are also government land. So therefore, and this is your paragraph 10 at the affidavit. How can you take this stand?
Then we will say.
Annual patta's
that-
period is 1 year.
Have you returned that land to them?
Yes, yes.
So for the period that you have not paid rental, pay. I
If
think
if they are the patta holders. If they are the patta holders, my lord, then we can.
You set up करिए.
Yes, we'll pay.
Why do you challenge it? That is what the court says.
Why we have challenged it, my lord? Because the deputy commissioner has asked, my lord, to pay the land acquisition compensation to us.
No.
That is there, my lord.
There is no
Page 233, my lord, page 233.
यही नहीं है तो compensation कहाँ से देगा?
My lord, page 233. That is the deputy commissioner's communication after the learned single judge's order, my lord.
Yes.
Page 233.
Two.
Page 233, my lord. Second paragraph. It
What
is
is
also,
this document?
this is the communication by the deputy commissioner, my lord, pursuant to the honorable single judge's order, my lord.
No. This is communication by the
Deputy
deputy
Commissioner,
commissioner
Himachal.
and addressed to the deputy chief engineer of railways.
Yes, my lord.
Yes, what does it say?
It says, my lord, that this office, my lord, paragraph 1 I am reading, my lord. This office has submitted a list of 128 affected families occupying government land and 28 families in possession of private land after field verification. This is the report, my lord. They are themselves saying that 128 families are occupying government land and 28 families are in possession of private land after the field verification conducted in person of the High Court's order. And in response to your office letter dated 21/11/2022, the submitted list is prepared based on the circle officer's report after joint verification in presence of the officials of railway, land revenue officials and the affected person. It was made clear in paragraph 3 of the letter dated 17/5/23 by the circle officer C.C. Burgaon that no ownership documents are available for the affected families occupying government land. For the 28 families possessing private land, documents were submitted along with this office letter number dated 27/23, and the copies of the same are resubmitted again in enclosure of this letter. Now, this is important, my lord. It is pertinent to mention that your contention in paragraph 1 and 2 of your letter dated 9/11/23 has unfortunately missed to take into account the direction in para 5 of the honorable court's order. Although the railways have been repeatedly insisting upon the revenue ownership documents, it was cleared several times by this office that the proposal of compensation is prepared in pursuance of the Honorable High Court's order, which has clearly directed to deposit amount of compensation against government land also. Therefore, the question of ownership document does not arise. In respect of these 28 owners, my lord, who are the patta land owners, we are ready to pay lease charges. What has been communicated from the deputy commissioner, my lord, to us is, my lord, the
It's all right.
land
Now,
acquisition rate.
you tell us, where is the document taking their lands on lease? There must be
Yes,
some
my
documentation.
lord. Yes. My lord, page 435, my lord, of the affidavit in reply, my lord, which we have filed. My lord, in the writ appeal, page 435.
You have read one part of the affidavit of the government, or the communication of the government, communication of the deputy commissioner,
My lord,
and you have not read the third paragraph.
I will.
Now read that third paragraph, then, it's all
I will read, my lord.
messed up,
That-
Mr. Gupta. And in case of confusion, we dismiss the appeal. Unless you sort out the facts. Now, what is this? Regarding para 6 of the same letter from your office, it is evident from field report that although the railways initially intended for lease of the land, the use of the land is of permanent nature as a concrete road still exists in the scheduled land. It is clearly mentioned in the letter. This commissioner also is doing, this deputy commissioner also has made a statement based on the report, a report prepared in his room, in his office by the circle officer or perhaps the revenue karmachari. He doesn't know what he's doing. It exists in the scheduled land. It is clearly mentioned in the letter number so and so, dated so and so. Now, this statement, who can deny? Railways can deny.
But, my lord,
If the railway, just a minute, if the
there is
rail,
no permanent acquisition, my lord.
we are ready to.
That will be another process, my lord, if the land
Take
is
that statement.
permanently acquired.
Permanently land has not, if you have built a road and a bridge, it is permanent.
In that case, my lord, that was not before the London
You
single
give us,
judge.
don't take us to these paragraphs, make a specific statement on the basis of which we shall pass an order. we will forget about what single judge has done. There appears to be a problem in the consent. taking.
My contention is so far as the landowners having patta documents are concerned, we are ready to pay lease charges, my lord, which has been paid to the previous 53 landowners.
Now, if it is permanent, then
Then, my lord, there has to be separate land acquisition process, which has not been carried out. Admittedly, the affidavits by the Deputy Commissioner, Revenue Authority is very clearly stated, my
so you
lord.
will give them the rental.
That has
for-
to be,
Just a minute.
my lord,
You
verified.
make that statement that railways is, just a minute,
My lord.
no compensation for the land. Railways is going to pay for the lease,
My lord.
lease charges
My lord.
till the time, lease in perpetuity. Kahiye, it's as good as compensation. Say that. Say that. I think Mr. Mohanta will agree.
Till the time they have occupied, my lord, not for perpetuity, my lord, again.
But where
Pura-
is the statement? Give us the statement that we have returned the land.
No, they are constructed.
It was asked by the single judge.
Land has been returned, my lord, returned to them.
इनकी लैंड रेस्पोंडेंट्स की लैंड रिटर्न कर दिया आपने,
My lord.
उसकी बाउंड्री लेकर एक एफिडेविट आप दीजिए
My lord.
और कहिए कि जितना दिन हमने इसको यूज किया है
We'll
उतने
pay
दिन
the-
उतने दिन नहीं कर सकते हैं आप, आपकी रोड टूट जाएगी, आपकी ब्रिज टूट जाएगी. Therefore, you think that our anger was misdirected.
Absolutely not, my lord. I am trying to clarify, my lord.
What you are trying to clarify, you are creating further confusion.
No, my lord, absolutely not.
Maybe
I am
not,
trying to assist, my lord.
maybe not deliberate.
I am on the facts only, my lord. There was,
लेकिन आपके स्टेटमेंट से अगर हम लोग कंफ्यूज करेंगे तो डांटेंगे आप ही को.
obviously, my lord, I am,
We will lose our temper on you. We
My
are not
lord.
asking Mr. Mohanta.
my lord.
देखो ऐसा है, try and understand. आप जब तक समझिएगा नहीं, and unless you give a clear undertaking on behalf of the railways,
I will take.
we will go by the consent order. Unless you say,
Land
Yes.
acquisition.
I will take it, my lord.
just a minute. A big chunk of land was taken by the railways. Regular lease rental was being paid to some of them. With respect to you, with respect to Mr. Mohanta's clients, nothing was paid.
My lord.
Then ultimately they came that it appears that there is a permanent occupation by the railways, even in the garb of lease, and therefore we must be paid compensation.
My lord.
And in the meantime, the government also, who appears for the government?
You have to initiate the process instead of writing this letter.
What kind of letter have you written? What letter your DC has written? Now,
My lord,
this,
one thing, my lord, I may submit.
Ek
It is only
second.
for 28 families. The report which has come, they are the owners.
आप हमें respondents के तरफ से बताइए.
My lord.
Tell us about the respondents. They claim, अभी तो you are not there to decide whether patta was wrongly given to them
No.
or it was never given to
No.
them. Correct?
No.
The state also says that patta has been given. There is no denial.
My lord.
So therefore, they would be the owners of the land for all practical purposes if it is acquired.
My lord.
No disputes.
No dispute.
So आप हमें, you give us a detailed list chart. We will ignore the consent order by the single judge. You can't possibly give consent.
I will have to.
The state cannot give consent. आप इनकी जमीन नहीं है जो खैरात में बांट देंगे.
My lord.
That consent means nothing for a judicial order. अभी consent आप कर दें और मैं छोड़ दूं.
My lord.
Now you will have to say that what land did you acquire for by way of lease?
My lord.
When you acquire, there is a when you take it on lease, there is a documentation.
My lord.
With respect to separate plots of land, you will have separate documents because
Yes.
this is not government, this is you.
Yes. Yes.
So far as the respondents are concerned, you identify which are the lands that they are claiming that they are pattedars.
My lord.
Correct?
My lord.
Now we want a proof from you that those lands were used or not used.
Right.
If those lands were used or not used because they are still residing there, maybe it would not have been used.
My lord.
If it was used, you have to pay the charges for 12 years or 13 years
My
or
lord.
whichever. And the evidence of the fact that you have returned it
My lord.
and they are now in possession and you don't have anything to do with that land.
My
Now we will forget the estate and we will also absolve you of your responsibility. But don't try and show us all this communication and all this side or that side. They all mess up when there is a confusion.
I try to.
Everybody,
clarify whenever
everybody
I
tries to fish in the troubled waters. And unfortunately, we don't get swayed by all these correspondence and affidavit. Make a specific affidavit, otherwise your DGM or whoever high personnel will go for perjury.
But I am
आप बोलिए,
with my lordship's opinion, my lord.
forget about all these, papers.
Yes.
Say specifically with respect to the respondents, we will decide it in no time.
And my lord, if I may humbly submit, my lord, the report my lord has just read.
नहीं sir.
128, my lord, are government, out of 154.
We
There is a report, my lord.
We
which-
don't understand
they-
your argument. Make a specific affidavit, not your statement, by the railways. Connect it with corresponding document. If you have.
Okay.
इनकी पट्टा की document आपके पास नहीं होगी.
But
But-
report clearly says no.
We are not concerned with
This
the report.
report,
We are not concerned with the report.
no, the revenue authorities also have to assist.
Nonsensical.
No.
The report has no backing of facts. The report is only throwing the buck that no, the court says that to pay compensation and therefore it has to be held.
My lord, in fact,
Make a statement that the government has said that this is not the land of the respondents, even as pattedars. I own it and I don't want money for it.
there are, my lord, series of communications, my lord. If I may humbly submit, railways have made several communications, my lord, asking the
They are
revenue
not concerned.
regarding the
They
ownership
are not
documents.
concerned.
We
If you-
cannot give
If
ownership
you
document.
contest a litigation like this, you will be required to pay. Otherwise, you go in contempt. आप specify करके लिखिए, if these are the documents which shows that this land, how many times am I going to repeat?
I will do it. my
Am I the lawyer for the railway? बहस करते हैं, आप दिखाते हैं हमें communication and affidavit which means nothing to us.
lord. That was only for the purpose of showing.
File an affidavit.
That is not, my lord.
With the corresponding documents, we will have it, we will explain and we will say that the single judge went wrong in recording the consent. लिखाइए,
I will file it.
try तो अभी भी आप कर रहे थे.
I will file it. my
You
lord.
are trying even now, taking us and making us sift through the papers. Make a specific statement short of all this. उसको हम लोग फिर record से check कर लेंगे. Whether this was part of the record when the consent order was passed or when you have filed an appeal. Make a statement. Mr. Mohanta cannot unjustly be enriched only because of a consent order. That is very clear.
Millard,
आपको
even,
statement तो बनाइए, for you are the appellant.
even when the review petition was dismissed, then also the same counsel made a statement, we are paying.
No, because see, he took offense when the court said that you are making a wrong statement.
Yes.
This further hurt us. आप बहस करिएगा नहीं, issue समझेंगे नहीं. You
Young
will not-
man, my
you will
lord.
not, give the court the filtrate of what you say and you are taking us to different communication and paragraphs. ये सब नहीं सुनते हम.
My lord, page 165.
Now,
made his
if
statement.
you again refer to those things,
No,
we
my
will
lord,
dismiss the
statement.
appeal in.
No. Statement is.
When we say something, we mean it. Will say that there is utter confusion in this, therefore it is better to go by the consent order and you pay.
Will file appeal. Sorry. No, I have just.
You have unnecessarily wasted our energy. We must say that.
What?
Had you been a private party, we would have imposed cost for you. बताएंगे नहीं आप और communication दिखाएंगे. Where is the statement? Don't show us those
It
papers.
is there.
File a separate affidavit.
Separate. Always is there. I'll file separate.
कुछ नहीं है आप again you're saying
165 is there, my lord.
कुछ नहीं है कुछ नहीं है कुछ नहीं है. Otherwise you would have straight away argued them. If you think that by asking us to go through maze of papers and this communication and that communication, I'm sorry, you have not judged us properly. Categorical statement दीजिए, हम order pass करेंगे. We can even say that this consent order is set aside or shall not be acted upon so far as you are concerned. कह सकता हूँ मैं, लेकिन उसके लिए definite evidence रहना चाहिए. फिर हमें वो communication दिखाइएगा, इधर उधर करिएगा तो फिर मैं dismiss कर दूंगा आपको. The easiest thing is to dismiss.
There is a serious misunderstanding on the part of the railways regarding the ownership.
I can
I
understand.
could understand.
Lordship can get it.
No, we are
This is a very serious, peculiar issue, my lord. Because those land, I may just indicate.
He was representing the railways in review.
No.
He should have said that.
He said that we are paying.
No, before the single judge, I was.
He
not
said,
there.
no, not before the
Before
single
that,
judge.
Mr. Gupta, you also clarify yourself under Assam Land and Revenue.
Exactly.
Regulation, what is the characteristics of a land?
Exactly, that is to be.
More particularly in case of an acquisition.
In any case, Mr. Mahanta,
Hello.
if the land has not been permanently acquired, they have not constructed anything, then you only get,
Lease.
because there is
Well,
no acquisition proceedings. You
Well,
only get the lease
True,
charges.
true. But then, fact remains that the land has been taken and permanently utilized. Gone. Nothing has been paid.
Even then,
Then
acquisition proceedings, they have to
No,
begin.
we start.
Just a minute.
Now,
If-
legally, yes.
They will have to give you lease charges for perpetuity. That would be
Exactly.
like compensation only.
That compensation regarding everything, because we have been deprived of all benefits.
Compensation has created all this
All
problem.
this problem.
What compensation of land if there is no acquisition? That way he would be justified in saying that there is no acquisition. I'm only using
No,
it.
they have assessed the compensation. This is the award was assessed.
Problem is, everybody has done everything without following due process.
Exactly. But
Ab ye, the DC made an estimate what amount should be paid. And then he is reneging from it because he sees that there is no acquisition.
yes, no, well, what happened?
You
What
have to
the
get
Railways they are not the acquiring authority.
authority.
No.
They will only give
Yes.
a requisition and the state would
But the
requisition.
state-
They have to
would
get, they
say,
are also not occupying the road. This is the problem.
Land belongs to
आप
the
अगर अपनी
state.
जमीन use किए हैं तो you will have to pay. Nothing comes for
We
free.
are ready to pay, my lord.
Nothing comes for free.
We are ready to pay, my lord. That is, but we are asking.
We'll,
the
we'll
land
direct, we'll
acquisition, they
direct for a fresh,
categorize
fresh
directly.
land acquisition process based on their claim
Yes.
and then give
Then
back
you
the
have to-
2030.
that-
तो 2013 से
pyramid
खुद
देना.
लो.
हाँ,
Otherwise you say whatever you want
हाँ.
to say.
2013 में
These
इसका-
charges we are ready to pay, my lord.
Half the railway stations will have to be shut down.
हाँ.
आप अभी हम कोर्ट की इतनी ही डांट से आप सेंटिमेंटल हो जाते हैं.
No, no, lordship. We are-
हमारे यहाँ बहस करने पर उससे घबराइएगा तो फिर बहुत मुश्किल है. This is a family where we can shout.
My lord.
Well, with experience and further age, probably things will develop.
Mr. Borua, we may have asked you to file an affidavit, the deputy commissioner. Be ready with your instructions.
Because the deputy commissioner can land himself in soup by making such communication and creating confusion.
And he can clarify the dispute, na? Fiscal.
And we ultimately, we will leave it to you, that you decide. ऐसे तो confuse करके आप कोर्ट से order ले लिया. Consent. And Mr. Gupta was hell-bent to have same confused order here from us.
I had to file appeal, dismiss, then review, my lord. Somehow I.
Rightly, you have not done, I mean,
Otherwise,
the-
I was.
see, if I start, plowing the field outside the court and I say that I'm very tired because I have work, that is not the work which is mandated, no.
No.
Your work is not only filing an appeal and getting it dismissed and withdrawn and reviewed. अब आप material ही नहीं लाएंगे, collate नहीं करेंगे and you say that you have worked.
No.
Unless you work in a directed fashion. Desultory reading or desultory argument से क्या होगा? Has to be targeted, no?
No.
आपने बहुत energy मेरा waste करा.
Supplementary list for hearing item 30 and 31.
Give us 2 minutes.
Yeah, I have 20 places.
We are-
Now there is another, my own is.
This is part of the.
Yes. Now, please read the FIR first.
FIR Lordship
Give us the page number.
Page number 3.
Page number 3. Yes.
Humble submission is that Vinita Das is my sister and Hiya Das is my niece. The aforementioned accused number 1 is the husband of my sister Vinita Das. About 19 years ago, the accused number 1 married my sister, and after that he began to torture her physically and mentally in various ways. On being instigated by accused number 2 and 3, the accused number 1 often threatened to kill her by showing dao and axe to her. At around 6 p.m. on 13/10/2023, where Nitu Das, Ankita Das, and Mayuri Das, who came as guests to my sister's house, were about to leave my sister's place, they saw that accused number 1 had locked the front gate of their house. Then when my sister Vinita Das asked the accused number 1 to open the lock, he, instigated by the accused number 2 and 3, grievously injured my sister with dao and axe. Witnessing it, when my niece Hiya Das came forward and tried to stop him, the accused number 1 brutally killed my sister and niece with dao and axe. When the guests witnessed the incident, accused number 1 threatened to kill them as well. So they saved themselves by entering my sister's room and locking the door. Therefore, it is prayed to you to register a case against the accused persons and arrest them and take necessary action.
All right. Now let us see the deposition of PW1.
PW1, Lordship will find at page 9.
Yes.
On 13/10/2023 at around 5 p.m., I received a call from one Ankita Das informing that my younger sister Vinita Das and Hiya Das were killed by accused Rishabh Das. Reaching the house of accused Rishabh Das, I found dead bodies of Vinita Das and her daughter Hiya Das lying on the veranda of the house of the accused Rishabh Das. I also noticed Ankita Das and Mayuri Das being examined by police. From Ankita Das, Mayuri Das, and Nitu Das, I came to know that on that day they visited the house of Rishabh Das, and when they wanted to leave the house of Rishabh Das, they found the gate of the compound of Rishabh Das was under lock and key. That when Vinita Das asked Rishabh Das to unlock the lock of the gate, Rishabh Das brought one dao and axe and applied blows on Vinita Das and Hiya Das, leaving both of them dead at the spot. Vinita Das had told me that Kamini Das, mother of Rishabh Das, and Junu Das, younger sister of Rishabh Das, had instigated Rishabh Das to finish Vinita Das. There was a divorce case between Rishabh Das and Vinita.
Just read the cross-examination. What is this cross-examination? Who informed him? Why did he not lodge the FIR? Why were the police
You are
there?
represented by legal aid counsel.
Legal aid consultant, yes. Legal aid consultant.
Yes, read that cross-examination.
I did not lodge any case against the accused person before the incident. It is not a fact that I did not state to the IO that the accused Rishabh Das had tortured my sister Vinita Das. It is not a fact that accused Rishabh Das is not involved with this case. That Rishabh Das is a mentally sick person, and at that time he was under treatment of mental sickness.
Now let us see PW3.
PW.
Ankita, who informed.
Yes. PW2 is also there.
PW3 informed, this is the.
This is no, PW3 has informed Ankita. According to his deposition, PW3 informed.
Ankita, Mayuri, and Nitu, the 2, 3, and 4.
Oh, you've just read, no, that he was informed by Ankita.
Lordship.
So therefore we would like to know whether he was there, he was not there.
Lordship.
2, 3, 4 we know, 2, 3, 4 were there. They are eyewitnesses. Now we want to see what Nikita told.
Lordship. Yeah. Nikita.
Yes, 13.
Okay.
This is for us to test whether these ladies were there, whether the information was rightly given, or it was just a post the occurrence because of the background of matrimonial discord, he was made an accused. This is what we want to see. And we want to also test the correctness of the evidence from you, since you have not cross-examined anybody in the manner that you should have. But I lay the blame on you. And the question is that he was there. The Rishabh Das was there in that house. Where did he run away? The police also reaches on 13th. But he is arrested only on 14th. And the investigation began on 13th. Where was he? What was done? So all these aspects you will be required to argue and build up your case. Otherwise, reading the evidence is not important. Now read.
Page 13, on 13/10/2023, I, along with my mother and younger sister Mayuri Das, visited the house of my friend here. At about 5 p.m., when we were about to leave the house of Hia, we noticed that the gate of the compound was locked. Hia's mother, Binita Kuri, then tried to break the lock of the gate with the help of a hammer. Then Hia's father, Rishabh Pura, came near Binita Kuri with a dao in his hand and applied several blows with the dao on the person of Binita Kuri. In the meantime, Hia came and embraced her mother. Rishabh Das then applied blows with the help of dao on Hia. Out of fear, we rushed inside their house. We also heard shouting of Binita and Hia for help. My mother informed police over phone. Police came and examined us. Police produced me in the court to give my statement. Exhibit 5 is statement in the court. In the compound, I noticed my mother and sister of Rishabh Pura standing. They did not resist Rishabh Pura. Cross. In one of the rented room, there is a separate room in the compound, and one thoroughly was in that room at that time. The distance between gate of the compound and the house of Binita Kuri was about 30 feet. It is not a fact that Rishabh Pura is mentally sick person, and at the time of incident, he was under medical treatment due to mental sickness.
ऐसे क्रॉस एग्जामिनेशन पर तो कुछ नहीं होगा. Now come to PW 19.
PW 19.
This is just a formality. Was he a legal aid counsel or something?
Legal. State it.
52.
I don't know how.
No cross
Lot
examination.
of scope by the.
Lot of scope. He could have questioned. All of them could have been tested.
Scope by the.
Yes, PW 19.
Page 52. Today I have appeared before this court after receiving the summons. On 13/10/2023, I was working as Sub-Inspector of Police and posted at Borpeta Sadar Police Station as attached officer. I was in the charge of Borpeta town. At that time, Inspector of Police Ranjan Dole was the officer in charge of Borpeta Sadar Police Station. On that day, at about 5 p.m., one Santanu Das over phone informed OC Borpeta Sadar PS that at Gandhinagar, one Rishabh Das caused grievous injuries to his wife and his daughter. After receiving the telephonic information, OC Borpeta Sadar PS opened Borpeta PS GD entry number 379 dated 13/10/2023 and directed me to take necessary step. Exhibit P16 is the exact.
Now, this GD entry number 379, is
Yes.
this an exhibit?
Yes,
Yes.
page 180.
Page?
180.
Just keep page 52 in mind and come to page 180.
Look.
This is how it has to be done. Yes.
Now I'm reading page 180. Okay? Now one Santanu Das phone number has informed over phone that Rishabh Kumar Das, a resident of Gandhinagar under the jurisdiction of this PS, assaulted his wife and daughter in connection
All
with
right.
a
Now
domestic.
come back to page 52 again.
Also. Exhibit P16 is the extract copy of Borpeta PS GT entry number 379 dated 13/10/23 is a signature also. Thereafter, I with police staff proceeded to the place of occurrence, that is the residence of accused Rishabh Das. I found 10-12 people on the road in front of the house of accused. I entered the compound and found dead bodies of a woman and a girl on the veranda of the front house. I noticed several injury marks over the dead bodies. I entered the house and found accused Rishabh Das. I noticed blood stain on the wearing dress of the accused. So I apprehended him. Accused identified the dead body. One of the dead body was his wife, Vinita Das, and other dead body was his daughter, Hiya Das. Accused confessed before me that he killed his wife and daughter by means of dao and axe. One axe with blood stain and a mobile phone handset were found lying near the dead bodies. I preserved the place of occurrence. Informed to my senior officers. In the place of occurrence, there was another house. After a few minutes, one woman and two girls were coming out. They identified themselves as Nitu Das, Ankita Das, and Mayuri Das. They told me that they had seen the incident. They described that they came to attend in a marriage at Gandhinagar and visited the house of accused. The accused involved with exchange of hot words with his wife, and thereafter he attacked his wife and daughter by means of dao and axe. On the spot, I recorded their statement under section 161 CRPC. On 16/10/23, I produced them before the judicial magistrate for recording their statement under section 164 CRPC, and their statement under section 164 CRPC were recorded. In the meantime, senior police officers arrived at the spot. The sub-inspector of police, Diki Talukdar, at that time was acted as crime scene officer in connection with serious offences registered at Borpeta and Howli PS. She also arrived at spot, and she took photographs of dead bodies, collected blood from the dead bodies, also collected blood mixed soil from the spot, and also collected blood-stained cloths from the dead bodies. He also collected hairs of the deceased from the spot. The accused had shown me the dao which he used in the crime. As shown by the accused, the dao was recovered from the house where he was sitting. I seized the axe, the dao, and the mobile phone handset. Exhibit P7 is the seizure list, whereby I seized one dao with orange color plastic grip. Exhibit P8 is the seizure list, whereby I seized the axe with grip, one mobile phone handset, blood stain collected cotton, blood stained piece of cloth, some control soil from the place of occurrence, blood stain collected in a cotton.
We have seen that. Now come, we are testing it on a different angle. Now come to PW5.
Page 16. On 13/10/2023 at around 4:05 p.m., one day when I was taking rest in my house, I heard shouting from the compound of Rishabh Das. Then I went out and noticed Vinita and Hiya lying dead with injuries in their courtyard. I also noticed Rishabh Das with an axe in his hand, roaming around at the dead bodies. Then police was called. The compound, which was locked from inside, got attacked by police. Police seized one axe, one dao, and blood-stained cloth from the compound of the accused Rishabh Das. Police took my signature as seizure list. Exhibit P7 and P8 are seizure list. In the compound, I saw one woman and two girls. Later, I knew that they were guests of Vinita. I proceed to the place of occurrence with Prijit, Vikas, and others.
No stands contempt. And it was very contemporaneous that before he had seen the attack, he had informed the police. And on his information, the police came. This statement is not correct, that Nitu or Amita informed him. But in any case, it was all very contemporaneous. So why was the accused not arrested that day? Where was he kept? He was supposed to happen in school. Produced किया है on 15th. He's been arrested on 14th, produced before the magistrate on 15th. Gap. 。 . 。 । 。 . 。 . 。 . 。 . . 。 . . . . . . . . . . . 。 . . 。 . . 。 . . 。 . . 。 . . 。 . . 。 . 。 。 . . . 。 . . .
。
Now let us see the doctor. And then we'll come to PW6, the neighbor.
Doctor who conducted postmortem PW60. Age 42.
Age?
42.
Postmortem was done on 14th, no?
14.
Several attacks.
Multiple. October.
October.
Back pain.
Even in October, Mitra has arrived. The timing को भी extend नहीं कर सकता है. All right. Now let us see what the neighbor has to say. Karnishta Kataki. Akati. W6.
Yes. Page 15. So, Mr. Kataki.
Clear?
Rishabh Das is my immediate neighbor. On 13/10/2023 at about 4:30 p.m., hearing hue and cry near the compound of accused Rishabh Das, I went near the compound of Rishabh Das, but the gate of the compound of Rishabh Das was locked from inside. I noticed Rishabh Das with an axe in his hand moving within his compound. That already some people gathered outside of the compound of Rishabh Das. From them, I came to know that something had happened inside the house of Rishabh Das. Later, police came. I also came to know that in the house of Rishabh Das, the bodies of Vinita Das and her daughter were lying. Later, I came to know that Vinita Das and her daughter had died. Vinita had told me that Rishabh had harassed her both mentally and physically, and sometimes the accused had gone to the extent of abusing her physically. Vinita and her daughter used to reside in a separate house within the same compound. Rishabh has also damaged the house in which Vinita and her daughter used to reside. The surrounding of the compound of Rishabh was covered with CI sheets of about 7 feet high. I did not enter into the compound of Rishabh Das on the day of incident. It is fact that I did not state to the police that Vinita had told me that Rishabh had harassed her both mentally and physically, and sometimes the accused had gone to the extent of assaulting her. That Vinita and her daughter used to reside in the separate house within the same compound. That Rishabh has also damaged the house in which Vinita had resided because police did not ask me these facts. Rishabh Das was unsocial, but he was not mentally sick person. He earned his livelihood by running a photostat shop.
When he was inside, he was in that.
No defense witness as well?
No.
तो सवाल ही नहीं पूछा मिस्टर अहमद. You have not cross-examined anybody on any
That
aspect.
is where I also.
So it becomes everything is contemporaneous. What do? There is no space.
And in fact, in 161 and 164, I have checked. Also,
What 161?
there are some.
We have direct evidence.
Persons that given those were contradictions.
161, 164 क्या करेंगे? उसकी confession थोड़ी अभी देखने की जरूरत नहीं.
Those contradictions were not brought. That is the reason. One aspect, Lordship may consider that mental insanity that plea was taken.
Sudden and grave provocation cannot be for assaulting two ladies. Own wife I can understand. There would have been some matrimonial dispute, but that does not stand established. There is nothing on record to say what was the matrimonial case. These neighbors also don't claim to have told the police that there was matrimonial discord. There is only one material, which would be an illustration as coming under illustration 114, something A, B, C or D, whatever, that they were staying in a separate house in the same compound. But you don't come in that exception also of sudden and grave provocation. Then there does not appear to be any provocation of any kind.
Lordship may consider section 329 of CRPC, Lordship, that judgment paragraph 56 and 57.
Mental illness. Where was that issue raised?
That cross-examination was their trial court of
Not at all.
for psychiatric.
Read 329.
Rather, he.
What is the corresponding CRPC section in the new legislation?
Rather, he is not a mentally ill person. This is the design.
Achha, this is a case of before the act came into existence. No, so 329. उसका कुछ consideration करता है.
Clause 2, Lordship.
They have suggested that he is not a mentally ill person.
There is no occasion for the trial court to have initiated a proceeding under this chapter. Chapter 25.
Because PW 10 admitted that
even otherwise, it would have been there has to be a legal insanity. Legal insanity you have to support from the surrounding circumstances. You know the McNaughton's rule. Have you heard of it? Huh? McNaughton was a person who wanted to kill the British Prime Minister Edmund Peel. And he aimed a shot at him. And later he took the plea that I did not understand the nature and quality of my act. And therefore, he put it up as a complete defense under the British law that he did not understand the nature and quality of the act. And there the matter was decided, and it is called McNaughton's rule to decide what insanity would provide a defense. Mr. Agarwal, you are aware of this McNaughton's rule?
No.
It's a legal insanity and not actual medical insanity, which is to be taken into account for complete defense under the exceptions. And based on that, we have also introduced it in our system, Garci Bai, if I remember correctly. Garci Bai, who had killed her children by throwing everybody in well. But she ran away when she saw the police. It was difficult to say that she did not understand the nature and quality of her act. And that is how it has to be deciphered from the surrounding circumstances. But यहाँ पे question ही नहीं पूछा, कुछ किया ही नहीं है. Nothing has been.
Proceeding evaluation, they have put the suggestion, but don't deny it.
So that is not the
And
way
they
to
are-
start a
In
proceeding.
313, he has not taken the.
313 में he has not taken that plea. How will he take that plea? It is for that, then it was for the court to understand. And then he's there. He's there. He, by sudden provocation, because these three, 2, 3, and 4 were there, it was only for their exit that the lady, the deceased, the wife, wanted the lock to be open. So they were there. So if he had any problem, he was mentally insane, he would have attacked one of them also. So he attacks the wife, and when the daughter comes to her rescue, he attacks him also. It could be a case, I mean, there could be some circumstance for grave and sudden provocation, but then there is nothing on record to suggest that there was any exchange of hot words and he became very angry. Nothing.
In 164, or you know, there is something. Not in the evidence. Not in the. 164, they say that there are some.
रास्ता ही नहीं छोड़ा है कोर्ट को कुछ देखने के लिए. They have not left any space for us. बताइए आप सेंटेंस पे बहस करिए. He owns a photostat shop. Correct. No earlier complaint. And for all this while, is there a report from the jail authorities, which is a must now? After that, what is that judgment which says that that aspect must be gone into social information report? Which is that judgment? मैं अभी criminal भूल गया हूँ सर. बताइए जरा वो that judgment. Manoj Kumar and
Manoj Kumar, and then last is Manoj Baruch.
बताइए.
Two aspects they have to take into consideration, my lord, that.
Then give us the judgment now.
Cyprus.
My lord, that decision is not the 2023-2, ICC 353. There are two 42-52. And there is a subsequent case, my lord, of Manoj Pratap Singh also.
ये तो कुछ सेंटेंस देखते हैं कैसे किया. सेंटेंस लाया है.
Oh, yes, sentencing part. Part 3, yes, sir.
ये 21 पे बहस कर रहा है.
What is sentencing for 2 more?
ये मिला.
Yes.
More others, yes. इसी को देखेंगे लास्ट.
There are 237 mitigating circumstances. There is a bill quoted from Bachchan.
No, बच्चन से छोड़िए अभी दूसरा we have something else. ये रविंद्र बहुत है. We don't want that. He wants that direction of the Supreme Court that for sentencing, there must be sentencing.
Page 250, sir.
Just to put it.
Paragraph 250.
Collect additional information.
Page 249. Paragraph 249. To do this, the director must take information from the state board.
Jail conduct behavior कुछ नहीं किया.
249.
Convert कर दिए. उसका using custody 2014. 2000? No, 20. कब है? 14, 10, 24. Permissions which was एक छोड़ दीजिएगा. With or without permissions कुछ छोड़ के. First line.
ये discussion में हमारे in the
No, Come to page 250 and 251.
Yes.
249.
That exercise has not been completed, no?
That has not been done, and the trial court also.
And even otherwise, it is most heinous offense to kill wife and daughter both in one go, but not rarest of the rare.
Not rare. That's my concern. So, my submission is not a case of death sentence. And other, conviction, is.
Conviction is,
Difficult to,
conviction is totally sustainable.
Can it be brought to 304 and all?
No. No, multiple attacks.
Multiple injuries.
It comes under
No
three,
cross-examination, nothing is.
302 thirdly. Clear. Birsa Singh versus State of Punjab. Who will give them everything? 303 per year. Section 300 thirdly. They say thirdly.
300
300
or 300. Thirdly.
thirdly. दोस्त हम लोग यही करते थे उस चर्चा पर नहीं बढ़ सकते बस ये मशीन होता ना समझिए
Hardly.
So that provocation is not given by anything done in lawful exercise of the right to bear.
नहीं अभी राइट ऑफ प्राइवेट डिफेंस का जगह कहाँ है सेक्शन 300 thirdly
What that? I'm sorry. I'm sorry.
read 300 full
If it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause.
वो 330 में आएगा ना multiple attacks he is making their intention इनका था या नहीं था it was sudden and great but he must have known that he is using a dab is a sharp
Multiple injuries.
multiple so
It was not only one year. So maybe it was not motive.
no 304 even first part
I'm not taking it. I thought that can it be not.
that is completely closed oh बहुत मुश्किल है I was only seeing that in who provided the information to brother PW1 no that is very good.
Who is that? PW12. PW12 is stated that I informed.
So many even Ankita says that you
Ankita did inform the.
but that confirmation comes only from PW19 no the IO Santanu had informed
That's
Santanu said all right sentence पे क्या बोलना है we have seen the judgment we know the judgment और एक और है there is one more separately by Justice Ravinder Bhatt
रविंद्र भट्ट
सब डिटेल लिखा हुआ है
I had given all.
तीनों को निकाल कर दे दीजिए
जी
नहीं बता
नहीं आराम से सकता
ठीक है ये सिग्नेचर भी कर देंगे
एक बात को ओरल लिखने वाला है ये
सिंगल क्वेश्चन से आएगा ये
नहीं ठीक है What are you finding out?
Give us.
I have given the candidate.
हाँ
Of the decision.
निकल लेंगे
All the the latest decision of Manoj Pratap. Manoj Pratap is the latest decision on this.
नहीं there is something after Manoj but it follows Manoj as by the same author the same author Justice Ravinder Bhatt
I will place the judgment to the court master.
arguments heard judgment is the result give your appearance slips you have to say something
Lordship, in respect of Lordship, rarest of rare offense, I only say that it's a Lordship helpless women and children Lordship. That part should be considered.
that's all right but not death
Lordship, in this regard,
rarest of all.
Lordship.
Plus the formalities which had to be complied with
Lordship.
Not formalities, the requirement.
Lordship,
Sorry, I'm
Lordship.
sorry to use the word.
Lordship.
These are no formalities, these are requirements.
Lordship, Lordship.
That has not been done. There is no special report from the jail. His
Lordship,
conduct, we do not know. How do we justify?
That
The
part.
ability of reformation also, that aspect has not been proven. Rather it said that he cannot be reformed. That nothing was there, nothing was there. And you know, the state.
Oblige, Lordship. Oblige.
Just give your appearance slips. You two advocates also give your appearance slips. You have been listening to the argument.
Lordship, Lordship.
Read that judgment first.
Lordship, Lordship.